This is a part-heard appeal in the matter of Zaha Hadid Limited and Zaha Hadid Foundation.
Mr. Abrams, just before we start, the court will rise at 1:45 today and sit again at 1:45, so we're going to bring forward lunch by quarter of an hour. Just to let you know.
My Lord Justice Popplewell challenged me to give an example of the word indefinitely being used to mean forever. And of course, one of the challenges is that nothing in this word, if you really want until the crack of doom, people who talk, even when they use the word forever, don't mean forever, because humanity is going to come to an end long before the end of the universe. Nevertheless, I've got some examples which are illustrative. Can I hand them up and explain why I say that they're helpful to your lordships? So that's three clips. Now, the only area in which you could really have forever, in which one can discuss forever in terms of till the crack of doom, is in physics. Okay, not because there you can have the concept of forever. And one context for that would be Newton's first law: a body at rest or in constant motion will not move or change direction unless an outside force acts on it. And if you Google Newton's first law and indefinitely, you get lots of results. The first one I like because it actually uses the very word forever and indefinitely interchangeably. So if you go on to the second page, understanding Newton's first law of motion, first paragraph tells you what it is, which I'm sure your lordships all know. And the second paragraph says, in simple terms, Newton's first law states an object at rest stays at rest, an object in motion stays in motion with constant velocity unless acted on by an external force. Then in the next paragraph, they break it down into two parts. So first, an object at rest. According to Newton's first law, this object will remain stationary indefinitely unless a force acts upon it. Indefinitely there does mean until the crack of doom. That really, if a force doesn't act on it, it will remain at rest until the crack of doom. This explains why a book on a table doesn't spontaneously start moving. Then the next paragraph says, the second part of the law deals with objects in motion. It states that an object moving with constant velocity will continue to move at the same speed and in the same direction forever, unless acted on by an external force. Forever there really does mean until the crack of doom. Notice that they have used forever and indefinitely interchangeably, exactly as I suggested. And notice also, my lords, you could delete the words...
They being the authors of the study pug.
Yes, they've used that. But notice also, my lords, that you could cross out the word indefinitely and cross out the word forever, and the sentences would have the same meaning. But they're there as words of emphasis. Just as in clause 12.1, it's a word there to mean, we really do mean it's going to continue. So in the non-physics examples, this example is the USPTO. And they say in the bit marked, hopefully marked, sidelined, rights in a federally registered trademark can last indefinitely if you continue to use the mark and file all necessary maintenance documents. Now, no doubt one could think of some ways of it coming to an end, but that means effectively indefinitely. So that's an example of it being used, effectively forever. That's an example of indefinitely being used by the US Patent and Trademark Office to mean forever, essentially. And the final example is the concept of indefinite leave to remain. Indefinite leave to remain in UK immigration law doesn't mean, well, until we change our minds. It means permanently. Obviously, like everything other than Newton's first law, there are exceptions. But it means permanently. And the print-off has the UK Parliament using the word permanent to describe indefinite leave to remain. That's on the final clip, the second page, again sidelined. So, permanent residence, also known as indefinite leave to remain or settlement. So they're using permanent and indefinite to mean the same thing. Of course, like everything other than Newton's first law.
And in either case to mean forever, because if one uses the immigration context, it may not be very helpful. If you commit an offence which is imprisonable for a certain period of time, then you're liable to deportation and so on.
Absolutely, and it's the same with our with our contract, I'm not saying that indefinitely that 12.1 means that there is no possible way that we can imagine the contract coming to an end, but it does mean essentially forever. Please, so
I mean, there are some cases on contracts which describe things as permanent, which interpret them as meaning not forever. If you are engaged in response to an advertisement which offers permanent employment,
for example,
it's determined on reasonable notice.
no, indeed.
There's a case, I think, where someone was appointed the permanent attorney for an entity, and that simply meant standing counsel until given notice that they don't.
Indeed, and what
These words take their meaning from their context.
absolutely, and that's why I gave you my 3 contextual points right at the beginning, of which probably the strongest is the presence of clause 12.2, which tells you that the licensor has the power to terminate on notice without cause, and therefore it cannot be the case that the licensee also has that right, otherwise it would be there.
But
and I'm going to and even Mr. Block's cases make that point, my lord.
I mean, the bottom line of my inquiry was really, I mean, do you know of any case which has held that one party in a commercial agreement or a quasi-commercial agreement, which has decided or treated the contract as not being contractually determinable ever by one of the parties?
I mean, I'm the wrong person to ask, but I don't have an example of that.
Well, I don't myself, and that's why I'm asking you. It as well as, you know, from that perspective, it would be a unique.
Sorry.
It would be a unique creature in my
I don't know why I said
in my
that.
limited experience.
I'm about to show you 2 examples.
Oh, well, good.
So I don't know why I said that. They both arise out of the consideration of my learned friend's old cases. So he relies on 3 old cases, and I call them old cases because they predate all the Supreme Court cases of the 21st century, which are now applied to the questions of construction. And one answer to these cases could be the Caliph Omar approach. If those old cases are in agreement with modern law, we have no need of them. And if they're opposed to the modern law, we must ignore them. And that's essentially what the judge did. He applied the modern law, and he can't be criticised for that. But since Mr. Block put so much reliance on them, I need to address them, unless your lordships tell me that you want to ignore them for the same reason. The first point, so I've got 4 points I want to make. The first point is to identify 3 aspects of the modern law which post-date these cases. Now, because these aspects are very familiar, I'm not planning to spend much time on the cases proving that these are part of the modern law. I'm just going to give you the references, if I may, to the Tesco Stores and Usdaw case, which emphasises these 3 aspects. So Tesco Stores is in the Authorities Bundle, tab 10 to 29. The first aspect that they stress is the focus on the meaning of the words used by the parties. So you get that in Tesco Stores at 33. That's Lord Burroughs and Lady Simler's judgment. They're quoting from Arnold and Britton, making the point, which I think your lordships are all familiar with, that you can't use commercial consequences to change the meaning of the words. If the parties agree to a bad bargain, they've agreed to a bad bargain. So that's the first aspect, the focus of words. The second aspect of the modern law, emphasised in Tesco Stores, was the separation of the questions of construction and implication of terms. As, again, your lordships, I'm sure, know, in Belize Telecom, Lord Hoffman made the point that construction and implication are really the same part of the same exercise. And in fairness to him, when he said that, there was a line of authority to support him, including my learned friend's old cases, that was consistent with that. And the Supreme Court in Marks and Spencer, and then strongly reaffirmed in Tesco Stores, says that that's not right. They're 2 separate exercises. Construction is about what the words mean. Implication of terms is about adding terms that are not there. So the references for that are 34 to 36 of Lord Burroughs and Lady Simler, and paragraphs 100 and 101 of Lord Legatt's judgment. And then the third aspect of the modern law emphasised in Tesco Stores is the structure and strictness of the test for applying a term into a contract. So this is the test which I'm not purporting to summarise, but involves considering business efficacy and necessity, and strict necessity. And you see that in Tesco stores in Lord Burroughs and Lady Simler's judgment, IBID, i.e. 34 to 35, and in Lord Legate's judgment, 102 to 106. And notably, both of them quoted Sir Thomas Bingham, Master of the Rolls again was, saying it is because the implication of terms is so potentially intrusive that the law imposes strict constraints on the exercise of this extraordinary power, as opposed to construction. So those are the three aspects of the modern law, which are now, absolutely standard parts of 21st century contract law. And so my second point is to show you that Mr. Block's old cases are out of step with these aspects of modern law. So his first case is Martin Baker, which is tab 6 of the authorities bundle. Starts at 183 of the bundle. But I'm going to start on page 204. So on 204, the final paragraph begins, the common law in applying the law merchant to commercial transactions has always proceeded more on the basis of reasonableness in filling up the gaps in a contract which the parties have made on the basis of what is reasonable. I mean, that is not the law of contractual construction in the 21st century, just filling in the gaps with what's reasonable. Then if you go over to 205, the paragraph beginning, it is of course true that this kind of consideration can in many cases be excluded by express provision, but where the contract leaves the matter open, I think that the common law approach would be to provide a solution which is reasonable. That's absolutely not the law. Where the contract is silent on a matter, then the only resort is to implication of terms, which is described as an extraordinary power, strict test, and so on. And he then goes on in that paragraph to say that he is construing the contract, not implying a term, but there are no words for him to construe, so he must be implying a term.
What is on your case, appellant seeking to do in this case? To construe or to imply?
Well, he's not implying in the sense that he's disavowed, he's disavowed relying on implied terms, but...
No, I understand what the submission is about
yes.
What is happening here.
Well, I would put it pejoratively as he's writing in a clause which just isn't there and which is inconsistent with the clauses that are there. That's what he's doing. I mean, if I'm going to come on to what I've got a brief submission in a moment. What if he had asked the court below or this court to imply a term, and what the result would be and why he would fail? But he's saying he's not doing that, he's doing construction. But he can't rely on these cases because these cases are about implication, or at least these cases are.
Well, you're going to have to deal with the possibility that he's in fact asking us to imply a term.
Well,
at some point.
Indeed. Well, let's go to the next paragraph on this page, an illustration of a case where there is something inconsistent with revocability of such an agreement is to be found in Reed Burker's Sportcrafts agreements. And in that agreement, if your lordships read that paragraph, you'll see that that was a case where the existence of express provision for determination in certain specified events meant that you could not imply or construe the contract as including a provision that it was determinable on notice. Now, I don't have immediately at my fingertips whether that contract had a fixed term for ending. So that was what I had in mind when I said to my lord, I was going to give your lordship some examples, but I don't. I might be wrong about that because I don't have in my mind whether this was terminable on. This had a fixed term, which I think was your question. I
think
think
that's slightly unsatisfactory if you're going to rely
yes.
on that
No. I realise.
as potentially
No.
an example. We can go off and look at it, but
No, indeed. I realise now that I hadn't fully taken on board your question when I said that. But the key point here is the existence of terms providing for determination in certain circumstances meant that you couldn't add, I'm going to use the word add, a term that wasn't there, providing for determination on reasonable notice.
could I ask that we be provided with a copy of
Yes.
that decision?
Indeed,
The
we
Law
will do
Times
that.
report is sometimes not very easy to find.
No, indeed.
Thank you.
Then Mr. Block's second case was the Spenborough case. That's quoted in his third case, which is the Staffordshire case. I'm just going to go straight to Staffordshire. So I'm in the first authorities bundle, and I'm just going straight to page 372 of the 384 of the bundle. So on page 384, my learned friend took you to the sideline passage, which goes over the page to C. And here, Lord Justice Gough is committing Lord Hoffman's heresy from Belize Telecom. In this passage, the two questions of construction and implication are clearly elided, and there's no recognition of the severe restrictions on the implication of terms which the court now recognise. And the line just above D on page 385 is particularly out of step with the modern law. The judge says, therefore, the defendants have to show, and the onus is upon them, why, there being no express power to determine this agreement, one to be inferred, but there is no presumption either way. The onus is not the heavy one of rebutting a presumption to the contrary. Well, that's absolutely not the law. The law now is the law of implied terms, where it is a heavy onus. And that was the point being made by Sir Thomas Bingham and quoted by in both the judgments and Tesco stores. So my third point on this is to show you how these are dealt with in the textbooks, to show you that what I'm saying about them is correct. The first is Sir Kim Lewison's book, which is in the Second Authorities bundle, and the relevant passage is at page 1058, tab 31. So if you're on page 1058, you can see that this is a heading terms about duration, but you can see above that it's in the chapter on implied terms, not on construction. And this is the section which addresses Mr. Block's old cases. So Spenborough is cited on this page around the lower hole punch or start of the marked passage. Staffordshire is cited on the next page at the beginning of point 6.169, and Martin Baker is cited on page 1061. It's example 2. And the principle to be extracted is in bold at the top of the page. Where a contract does not expressly provide for its expiry or determination, a term may be implied that the contract may be determined after a reasonable time on giving reasonable notice. And footnote 504 says there's room for debate whether an ability to terminate a contract on reasonable notice truly is an implied term rather than a question of interpretation of the terms of the contract. Since in such a case there are no express words relating to termination, the author considers that it is properly a question of implication. And I would respectfully say that the author is clearly correct, and that following Tesco stores, there's no longer any room for debate about that. The book goes on at page 1060, paragraph 6.172, to say, so too, where the agreement already contains for termination, it will be difficult to imply further such terms, which is obviously a core submission of mine. And the book cites Reed Burker's Sportscraft, which we saw described in Martin Baker, and it also refers to Colchester and East Sussex Cooperative Society and Kelvedon, a licence to use a car park was automatically terminable only in certain specific events. It was held that no general power of termination could be implied. So that's another example, and your lordship wants to know whether that was a permanent contract or had a fixed term. And I can't answer that question. I'm just telling you, I'm just acknowledging that question.
Potentially the best case for you is the Harbinger case, which you passed over at 6.170, which was a software supplier whose obligation to provide support for the software was expressed to be in perpetuity.
Yes.
And the court in that case declined to say that that meant that the support obligation could be terminated on reasonable notice. But the passage that's quoted is slightly misleading, not for the point that Kim Lewison is dealing with it for, because in fact the court in that case held in perpetuity doesn't mean forever. It means until the software has become obsolete.
Indeed.
And so that you couldn't have on reasonable notice, but it didn't mean forever. Even the words in perpetuity.
No, except that if the counterparty had perversely continued to use the software for 10,000 years, the obligation would have continued for 10,000 years. And
But not forever.
well, not forever, because eventually the Earth will come to an end, and that's the problem with forever, my lord. But when it becomes obsolete, the point in that case was that when the software became obsolete, the obligation would cease. But there was no obsolete meant when the counterparty stopped using it. So there was an assumption that one day the counterparty would stop using the software.
Well,
but no requirement.
There would probably, on the facts of that case, have been an assumption that within people's lifetimes, or possibly longer, all software would become obsolete.
No, that absolutely was the assumption.
And therefore it was foreseeable that there was a point of time in the foreseeable future.
That was absolutely the assumption.
But what that seems to illustrate is that even if it says in perpetuity, it doesn't mean in perpetuity. It means it'll come to an end at some stage, and in that case, it could come to an end not by the giving of reasonable notice, but by expiry of the usefulness of the obligation.
Oh, indeed.
But that isn't. One can't. Can one? Or can one? If indefinite in our case means in some circumstances the obligation will become obsolete, as it were, the contract will become obsolete. Can one identify what the circumstances are that would obtain in this case?
Well, I think we've canvassed 3 examples in the course of the discussion. One was frustration, although we haven't tried to identify what would constitute frustration. One would constitute the company being wound up. Then it would come to an end. Obviously, once the company is no longer trading and in existence, then obviously the contract is at an end, it's finished, it's done. And that, I would suggest, is the nearest analogy to the software becoming obsolete.
What about the marks ceasing to be registered?
That's certainly a possibility. There's an obligation on the licensor to maintain the marks.
Well, it's a more limited obligation. It's not absolute obligation.
Indeed.
In 3.8.
Indeed. Your Lordship, absolutely 3.8 is what I've got in mind. And that is not, I mean, this is purely hypothetical, and on a particular set of facts we might have a discussion, but that's a perfectly reasonable thing to say, that once, if the licensor owns no rights to license, then I can't see what the answer would be to, well, the contract would come to an end on the basis that there's just a failure of consideration. If the licensor ceased to have any rights to license, because the trademarks had all ceased to be registered.
What do you mean by failure of consideration?
Well,
that's not a doctrine which puts an end to a contract.
No, indeed, indeed, quite right. That's the wrong terminology. But your lordship makes a powerful point. I can't see an answer to if the trade to this point, that if the licensor no longer has any rights to license, then the contract just has to come to an end. It's like the software becoming obsolete.
That's what do you mean by right to licensing?
Well, it's
The
so
agreement is you can use these marks. The fact they're no longer registered marks and don't have a commercial value doesn't mean that the license isn't still a license of marks.
I was just being pedantic, my lord, in the sense that the rights license, the valuable rights license under this agreement extend beyond simply registered trademarks. But I'm agreeing with your lordship and just being pedantic about the way it's expressed.
But I don't want to spend a lot of time on various different examples, but one can see all sorts of examples.
No, indeed.
And indeed, there may be some of Rumsfeld's unknown unknowns in the centuries to come.
Well, I strongly embrace that as explaining what indefinitely means, and therefore juxtaposing that against clause 12.2, which makes clear that it's not talking about when either party wants to bring it to an end, because the question, can the contract be brought to an end by one party without cause, is clearly answered by 12.2.
I just wanted to raise that on Harbinger.
No, but I strongly agree with the points your lordship's putting to me, and they do help me. So just for completeness, and because it was raised in my learned friend's skeleton argument, Chitty. So Chitty also makes the point, sorry, I'm on page 1083 of the bundle. Chitty also makes the point in its latest 36th edition that these are to be this discussion is to be regarded as a question of implication rather than interpretation, and Chitty actually cites Sir Kim Lewison in support of that view. And in the middle of that paragraph, well, I'll let your lordships read that paragraph, but you'll see in the middle of the paragraph the sentence that I like. So obviously it's the sentence, thus a term is unlikely to be implied into the contract permitting the determination of the contract on the giving of reasonable notice where the contract already contains express terms which regulate the entitlement of the parties to bring their contract to an end. And I would add, a fortiori, very a fortiori, where the contract expressly gives one party the right to terminate on notice without cause. Finally, on Mr. Block's cases, it's not fruitful to work out how these cases would be decided today, other than to say that the debate would be firmly one about whether a term could be implied by reference to modern law on that question. The reason why Mr. Block has always disavowed a case of implied terms is for the reason I've shown you, because clause 12 makes detailed and complete provision for termination, including giving one party the ability to terminate on notice without cause. And as we've seen in the cases and in both the textbooks, that's pretty much fatal to any argument that a term should be implied in this case, but it's equally fatal to his argument on construction. And that's, I think, the best answer I can give to your lordship's question. My lords, I'm now moving on to the third heading on my third heading on the construction issue, which is on, and we can put away the authorities bundle. My third heading.
Just before you leave that, do you want to deal with the old case, the Winter Garden Theatre?
Yes, I think, so my friend doesn't rely on that so strongly. It's not one of his 3 cases, and I think that's because it's actually the clearest example of muddling up implication and construction of terms and not approaching matters as the court is now required to approach them.
Well, can we just step back from what people have said at various times? There you had a situation in which a license was granted, which could only be terminated by a theatrical company, but could not be terminated by the theatre owner, who were letting the company use the theatre. Right? So, you know, picking up maybe from what you've just been talking about, it was an agreement in which there was a right to terminate a license, but only on one side. Nevertheless, the outcome was that it was found to be that there was a right on both sides to terminate on reasonable notice. I'm sure there's more to it than that. Taking that case, was any other outcome conceivably possible? Can one possibly envisage a situation in which a troupe of travelling players is allowed to occupy somebody else's theatre forever, simply because there isn't a term in the contract that expressly gives them the right to terminate?
So your lordship puts a finger on it. These cases have to be fact sensitive, in the sense that there are a set of facts where, as you say, is it conceivable that could arise. It doesn't, in the sense of comparing facts, it doesn't help us because there's nothing inconceivable with a company.
But what it demonstrates, surely, is that there are circumstances, and there have to be circumstances, in which, I'm not being controversial about this, but the court has to imply a term into a contract to make it make any sense at all.
Indeed,
that, as it seems to me, is the actual argument that you're facing in this case.
So I agree with the first part of what your lordship just said, that you can never say never about an implied terms. If that case came before the courts today, they would apply the modern law on implied terms, which postdates the Winter Gardens. And for the reasons your lordship's given, I agree there would be your lordship expressed a powerful argument that, notwithstanding the existence of the right to terminate on the one side, there would nevertheless be implied a right to terminate on the other side. That's not how it was treated in Winter Gardens. It wasn't. The modern law wasn't applied. It was this sort of mix of implication and construction, not applying the principles that we now apply in the 21st century. And I can give you a good example of that in the authorities. But if you read all the judgments, you see all of them.
Yes, but again, I'm trying to draw back from the
well, I'm going to answer the second part.
aspect of this and just look at the practical aspect of this. But to repeat, as it seems to me, the argument that you're having to face is that the licence, as drawn up, and as you were defending it, makes no sense, because it cannot possibly be right that the company should be tied into this agreement without limit of time.
So I'm going to come on to the so my third heading is to dealing with the commercial consequences and the it makes no sense argument. So I'm going to deal with that on the facts in a moment, and I don't accept that that's right as a matter of fact, and I'm going to address that. But as a matter of that's the argument I'm facing. If I'm facing that argument is simply not open to my learned friend. He did not plead an implied term, and he expressly disavowed at trial that he was relying on an implied term, because I made this point. I made this point that we need to distinguish in what is it that we're doing, and that was a big part of my submissions at trial. He disavowed it. Obviously, when we in opening, when we talk about implied terms, there are a number of stages that need to be gone through, and evidence can be relevant to those. and the case was simply not approached on that basis, and it simply isn't open to my learned friend now to say, okay, if you're not with me on construction, then I ask you to be with me on implied terms. That just simply isn't open to him. But in any event, he fails on the facts, those facts being principally the existence of clause 12.2, and secondly, the factual matrix, which I'm now going to address, if I may, if that's convenient to move to that.
So just before you leave the construction implication divide, although the authorities are clear that they are two separate exercises, which you're doing in any particular case may be slightly difficult to decide. But assume, if you would, that contrary to a number of your submissions, you get to a stage where you have a term in a contract which is, as a matter of interpretation, to be interpreted as it will be capable of determination by either party at some indefinite point in the future. Suppose that's what it means, and suppose suppose that that's what this contract means, and one is then having to engage on the exercise, which may probably be categorised as implication rather than construction. Well, when is that future point of time? There is a future point of time. When is it that the parties are to be taken to have agreed that future point of time to be? Now, I know you say that's not where we get to, but if we were to get there, is there any other realistic implication or construction, if it be construction, other than upon reasonable notice? Is there any other contender as to what is necessary to answer that when question?
I understand the question. Can I have a think about that?
Yes.
But it's certainly not something that I've thought about or has been canvassed before. So parking that, the factual matrix, my learned friend used the expression commercial consequences. So whether you call it factual matrix, background, commercial consequences. My learned friend's skeleton argument also talked about absurdity, which I put under the same heading. He didn't talk about absurdity in his submissions. And our submissions are under the heading that's on page 63 of our skeleton argument. And we've got three high-level submissions under this heading. The first is simply the limited role of the factual matrix. It's not to be used to relieve a party from a contract that it's come to dislike. It's not, as in Mr. Block's old cases, for the court to just simply fill in a gap that it thinks is reasonable. That is not the law. Second, the factual matrix supports the judge's construction, not the company's. And these are facts that I don't think have been drawn to your lordship's attention yet. The first point is that the purpose of the licence agreement was to provide an income from Dame Zaha during her lifetime. Now that was uncontroversial, and the evidence references are in our skeleton argument. They're at footnote 6. In our skeleton argument. Second point on the factual matrix, although Dame Zaha was the 100% owner of the company at the date of the licence agreement, she intended that over time Mr. Schumacher and other senior employees would be given equity in the business so that she would no longer have control over it. That was uncontroversial at trial, and the judge made a specific finding that that was part of the factual matrix. That's paragraph 45.
As a matter of fact, had she in fact lost ultimate control by the time of her death or not?
No, it was on her death, under her will and her letter of wishes. She then gave the company to
The foundation inherited it under
the foundation
under the testamentary laws, but as a matter of shareholding in the company,
No, she was still 100%.
she was still 100% shareholder.
Yes.
Then.
Yes. Again, she died much sooner than it was expected. That was a matter of I can say that because it was a matter of evidence at trial.
Sorry, I diverted you. I just wanted
Yes.
to understand.
When I say much sooner than was expected by the company. I have no visibility of her own
Anyway, you were making the point.
Yes,
I'm sorry
but
to have
it was
distracted you.
it was part of the factual matrix,
That she intended over time to
Yeah.
divest herself of her.
and that was part of the factual matrix at the relevant date of the agreement.
Yeah.
So in those circumstances, it makes perfect sense for Dame Zaha, when granting a license of her trademarks, to require that the company not be able to terminate the agreement, thereby cutting off her source of income. Okay? So that's a very important part of the factual matrix. Furthermore, the evidence was that Dame Zaha and everyone else intended that the company would continue to trade under her name without limit of time. Again, the company's witnesses made that point very strongly, that Dame Zaha would not have wanted, that they didn't want to change the name, and that Dame Zaha would not have wanted the company to change the name. And we've given you the evidence and references for that in footnote 8 of the foundation skeleton. And Mr. Walker confirmed at trial in the witness box that the company wished to carry on using the name long term. So in those circumstances, it made perfect sense for the company not to have the ability to terminate the agreement, and would make no sense to give the company the ability to terminate the agreement. There was no reason for the company to have that ability, because the contracting parties intended that the company would just simply continue to use the name.
Forever? For hundreds or thousands of years?
The concept of the possibility of the company changing the name was not something that was contemplated as being a realistic possibility. I understand the point your lordship putting to me, and if the officious bystander had made the point that you made, hundreds of thousands of years, can we not think of anything? Then maybe the parties would have thought, well, actually, maybe is that a possibility? Let's discuss that. The evidence was that Dame Zaha regarded her legacy as being very important. That was front and centre of the evidence from both sides, the company and from my clients, and that was a key reason why the company were making the point so strongly that she would not want the company to change her name. So it's not at all, this isn't the correct way of putting it, but I'm going to put it this way. It's not at all unreasonable to think that if the parties had that discussion, Dame Zaha would have said, no, if I'm going to grant this license, it has to be forever, because I want my name to live forever. That's on the evidence. In this case, that is not at all an unreasonable possibility. But of course, my primary submission is the parties proceeded on the basis that the company would just continue to use the name. They didn't have that discussion, and it is partly a matter of pure speculation as to what would have happened if your lordship had been there. But to the extent that we have evidence, and we do have good evidence going to this question, there is a solid basis for saying that Dame Zaha would have said, I want my name to carry on. That's part of my legacy. As I say,
Mr. Abrams, it seems to me there's quite a difference between the situation that would have been contemplated as applying during Dame Zaha's lifetime, and the situation that might exist after her death. So that when we've been talking in generic terms about whether or not there should be construed or implied a term for reasonable notice, is it not perfectly possible to envisage that the answer might be different depending upon whether Dame Zaha was alive and dependent upon the income stream for her own use, or whether she was no longer alive and was simply concerned with the legacy issue? So that one might put this in different ways. One might be that reasonable notice, if there was to be such a concept within the agreement, would not be notice given during Dame Zaha's lifetime. Alternatively, that the reasonable notice provision that's being posited would only take effect after her death.
I completely agree.
So there may be,
no,
I'm sorry to talk over you, but there may be a more sophisticated way of looking at this than simply saying that it's one clause or not, or none.
Just for the transcript, the transcript correctly records me saying I completely agree. It doesn't record me going on to say what I completely agree with. So
Yes.
so please can that answer be read according to the following answer. I completely agree that on some facts that might be the correct answer to the question, whether it be implication or construction. Again, assuming it's pleaded. But on these facts, that argument doesn't work because the evidence was that she wanted her name to she wanted the company to continue to use her name after her death. So it is not on the evidence open to a fair conclusion to say that that the parties can be taken to have agreed that once she was dead, the company could change its name. That was the evidence was exactly the opposite way.
But I think
If
the
the evidence was different.
broader point my lord is putting is, if there were a term that it was turnable on reasonable notice, what is reasonable would be able to take account of all these factors, and it may be that in the light of what was the factual matrix and so on, the conclusion would be it wouldn't be reasonable to determine it until 30 years after her death, or 50 years after her death, or whatever it may be. That's all catered for in a single implied, assuming it's implied, term of reasonable notice.
Indeed, and on the hypothesis that your lordship put to me, then I can't disagree with what your lordship said. My point, whether I was answering my lord's question or not, is that the evidence is against any suggestion that the parties can be taken to agree or would necessarily have agreed that the position would be different after her death. Going to the anterior question of whether that could be a term in the first place.
But I entirely understand that point. But there is, of course, a difference between the position before and after her death. During her lifetime, she's in control, essentially. You give the Ferrari example of how a brand can survive long after the founding name, but it is rather dependent on what is done with it. If, since Enzo died, Ferraris had become cheap, nasty, and nothing that anybody wanted to buy, the mark wouldn't be worth very much. All I'm saying is I entirely accept that lifetime and post-lifetime is not necessarily a critical distinction, but there might be factors which operate in terms of what is reasonable, which differ as between the two periods.
Yes, you discussing what is reasonable, I don't have a problem with what your lordship's saying, but of course my point is that there is no such clause for reasonable notice, and what I've said goes directly to that. My final submission on the consequences, factual matrix, whatever you want to call it, is that it's the company's construction which is absurd, to use my own friend's word in his first argument. I obviously don't need that point to succeed, but it certainly helps. I think actually I've covered these points. One was given the intention that Dame Zaha would have income throughout her life, it would have been irrational if the company had been given the ability to terminate the agreement. Your lordship puts an answer to that, but to which I say that just simply wasn't part of the agreement. The other point is, as the judge pointed out, the company's construction creates this absurd anomaly in that the foundation have the ability to terminate without cause, A, on reasonable notice, B, on 3 months' notice. And I invited your lordships to think about the position as if I came on behalf of my client after 1 month, after giving 1 month's notice, to say 1 month is reasonable on the facts of this case. I wouldn't be allowed to develop the argument that it was reasonable. It would just simply be said, the parties have agreed 3 months, we're holding you to 3 months. What's wrong with that? Your lordships have to face up to that problem, because you cannot, and it is not suggested that you can argue that clause 12.1 gives them the right to terminate on reasonable notice and not my clients the right to terminate on reasonable notice. But since it can't possibly give my clients the right to terminate on reasonable notice, it can't possibly give them the right to terminate on reasonable notice. either. My lords, those are my submissions on the construction issue. I'm going to move to restraint of trade. Once.
Sorry to hold you
Lords
up.
happy.
Can I just ask what your case is on the various provisions we looked at, which
Yes.
are capable of being construed as imposing an obligation
Yes.
on the company to promote the
I-
brand?
Yeah, I was going to.
5, 3.2 and 4 in particular.
Yeah, I was going to make the point. I was going to address this in the context of restraint of trade, and I was going to start by making the point that because of the way that my learned friend's case has changed, we didn't spend time at trial discussing the proper construction of these clauses, and all of these clauses can be construed in a way which is completely unobjectionable and reasonable. So before I crack onto the detail, I would acknowledge that the contract assumes that the company will want to use the trademark for all its services. So when we'll look at whether or not it actually obliges them to do that, but it's written on that assumption, which assumption has proved to be correct, and has to be looked through that lens. So I've got a note, but perhaps your lordship can tell me the clauses that you want me to address in particular.
Well, I think the ones that I had identified were 4.
Well, let me do the one.
Let's start with 5.1 because that's perhaps the.
Okay. So
the parameter.
5.1 was the one clause that my learned friend addressed the construction of. I didn't address the construction of clause 5.1 at trial because I'd already finished speaking by the time it was raised by my learned friend. But we respectfully agree with the judge that firstly, this doesn't require the company to do anything that the directors regard as uncommercial. It does require the company to trade actively and is perfectly reasonable on that front in the context of a trademark license, because if trademarks are not used, then they become liable to revocation. And this was a grant of trademark licenses, of a license to use registered trademarks all over the world. If you glance at Schedule 1, you can see that it's granting registered trademarks in Europe, Asia, Africa, North America, and Oceania, and I don't see South America, yes. So every continent of the world. And if the company didn't use the trademark in South America, then the licensor would lose its valuable trademark rights because they weren't being used. So it's perfectly...
Unless somebody else used them.
Unless somebody else used them. In theory, of course, it's because it's a non-exclusive license. In theory, my clients could grant a license, but that does create complications and difficulties. My learned friend definitely reserved the right to bring proceedings against another company who used the registered trademark in his submission. Well, I certainly interpreted him as that there was a possibility that if there was another Zaha Hadid company in a part of the world, that his clients would complain about that. Whether that's right, whether I misinterpreted him or not, it is certainly the case that having a second Zaha Hadid company would bring with it complexities. And so it's perfectly reasonable and understandable why the licensor would say, I need you to use the trademark in all these territories in order that I retain my valuable trademark rights.
But just coming back to clause 5, if I understood, your submission is the obligation to use best endeavours to promote and expand the supply of licensed services on the maximum possible scale does not involve any obligations to use best endeavours to do that in relation to the marks.
It doesn't. It's written on the assumption that the use of that the use of licensed services will be done under the marks. So that's what it's there for. There is an argument that it implicitly requires them to use the marks in all those territories. That's just not something that we've gone into hitherto.
You say implicitly, but licensed services is defined to include
Yes,
exploitation of the marks.
yes.
So is it implicit or is it explicit?
Well, it's include but not limited to. So it's still a licensed service even if it doesn't use the mark.
Yes, but the supply of licensed services includes
Yes.
supply of services in relation to the mark.
Yes.
But you say that doesn't, as a matter of construction,
Well, I'm
involve a best endeavours obligation to promote, amongst other things, the mark.
I'm trying to avoid, I'll be frank with your Lordship, I'm trying to avoid answering the question because it's not a matter that was dealt with at trial
No.
in those terms.
But it has been raised in this court and
it has been raised in this court.
by the court, and ultimately it has been adopted
Yes, indeed.
by Mr. Block, and
Indeed,
therefore I think
And it's
you need to address it, even if your answer is it shouldn't be a matter that the court addresses.
and it's not something on which my clients have had a chance to reflect and choose a position. And I've not taken instructions from my clients. My clients not being a commercial organisation, it's not the sort of thing where I can phone up my clients and say phone up the relevant decision maker and say what's the position. So I'm speaking without instructions as to what my client's position would be. But given that the purpose of 5.1 is clearly to ensure that the registered trademarks are not vulnerable to revocation, it's difficult to argue that it's not implicit in 5.1 that the marks have to be used. Because the license fee is payable whether or not the marks are used or not, and therefore this agreement, if the license fee was only payable on the use of the marks, then the contract would be expected to be clear about when the marks had to be used and when not. But because the license fee is payable whether the marks are used or not, the contract in a sense doesn't care whether they're used or not to that extent, but this clause does care because it has that requirement.
And is the same true of clause 4, which requires, if the licensor so directs, that they be promoted?
4.1 is very, very difficult for me because that clause is clearly subject to the line of case law about parties acting in good faith and trust. That there are, by which I mean there are certain clauses in certain contracts which are understood to require the parties not just to rely on their strict legal rights but to operate them in a good faith manner. And clause 4.1 definitely falls into that category because of its nature about providing directions. It's not something which was even raised by my learned friend in reply, and so it's not something that I or my clients have engaged with at all. But the real answer to that is, if that clause is construed sensibly, it is completely unobjectionable. And
or put another way, yes, it does require the exploitation of the marks, subject to what we might call for the shorthand the Braganza implication that you can't exercise rights in a way which is in bad faith or for improper purposes.
Yes, and the fact that I've never heard of the Braganza case shows the difficulty I'm in dealing with these brand new points.
Yeah, but that's what you mean by the good faith line.
It is. I'm sure it is.
And 3.2.
Well, 3.2 is a little bit clearer. So it's clear what 3.2 does and doesn't require. Obviously, it's expressly subject to reasonable directions. The word reasonable. And equally clearly, it is subject to the line of authority that the Lordship and I have just been discussing. What it does require is that when the licensee uses the marks, it must do so in accordance with any particular formatting that the licensor has notified, if any. So if the licensor says, look, I only ever want you to use Zaha Hadid in capital letters to make it clear that it's a trademark, then, where possible, then that would be an example of a direction under this clause. What it doesn't require is the use in any particular situation. So a clear example would be this. 3.2 does not allow the licensor to say, all your employees must always, when working, wear a jacket with Zaha Hadid on the back in big writing. But if the company chose to dress its employees in jackets with the word Zaha Hadid on, the licensor could say, okay, we want that the word should be in Times New Roman.
And it wouldn't be allowed to do the former because that wouldn't be a reasonable direction? Why?
Because when it says the licensee and its group company should use the marks in the form stipulated by the licensor, that means when it's using them. Either as a matter of construction or implication, 3.2 is talking about when the licensee is using the marks, it shall use them in the form stipulated by the licensor. And I would also add, it wouldn't be reasonable for the licensor to give directions of that sort. I mean, perhaps you might argue it's reasonable to say you must put it on your letterhead. I don't know, but
So it's implicitly to be read as if it said at the beginning, if and to the extent the licensing group companies use the marks, then.
I would use the phrase, well, my wording was when using the marks, but I'm not sure it makes any difference.
What about 3.4?
3.4, oh, that wasn't one.
The licensee and its group companies shall not, I'm focusing on the words particularly omit to do
Yes.
anything that may weaken, damage or be detrimental to the
Yeah, well, that, I mean,
reputation.
that sort of clause is absolutely standard in any trademark license. I think I completely endorse what my lord, the Chancellor said about judges just deciding whether clauses are reasonable or not. Some clauses are so common that even trademark barristers and judges can say this is completely standard, and this would fall into that category.
I know you've moved to the bit of your submissions that's restraint of trade. I'm not so interested about whether it's reasonable, just what you say it means for the purposes of construction.
Yes.
Does that involve an obligation?
No, that doesn't involve an obligation
to do things which involve promotion of the mark.
No.
Why not? If no steps are taken to use the mark at all, would that not be omitting to do something which would weaken, damage or be detrimental to
Yes,
the
but
mark?
to that extent it goes no further than 5.1.
But again,
So yes, so, potentially.
it would therefore require use of the marks.
I'm not sure how omit fits into that sentence at all.
Well, my lord, if the point, I think the point put to me, excuse me, is that if you are a licensee of a trademark and you don't use the mark at all, then after a period of time.
I'm just talking about as a matter of
Yes, it's
plain
not very,
English.
it's not
As a
very
matter of plain
felicitous.
English. If you just single out omit to do, then it then lists all the things that would cause the maximum.
Yes.
I think it must be.
So it's just drafting nonsense.
Yeah,
I think it may be one can make sense of it by saying shall not do or omit to do or permit to be done any act, and then insert where the act or omission will or may weaken.
that's exactly what I was going to suggest. Yes, that's exactly how we read
My
it.
lord is right. It's not very happily drafted, however standard it may be.
And then we mentioned 6.7 briefly. 6.7 needs to be read with 13.3, which says that termination or expiry of this agreement shall not affect rights and remedies that have been accrued to the date of termination. So the licensee still has to pay the license fee for the period prior to termination, and the purpose of 6.7 is to ensure that the procedural requirements of clause 6 still apply. So, for example, looking at 6.3, after termination, if the licensee owes a sum of money, then the licensor can insist that that money be paid in sterling to a designated bank account. So that's what 6.7 meant. That means there was some suggestion that, I don't know if this was where this went, but there was a discussion about whether royalties had to be paid even after termination, and that's certainly not the Foundation's position. 6.7 is not about not saying that you have to carry on paying even when it's terminated.
Unless they've accrued before termination.
Yes, yes, in which case 13.3 makes it absolutely clear they still have to be paid, and 6.7 says they have to be paid in sterling, etc. So, is there any more help I can give on the construction issue? So, restraint of trade, and the discussion of restraint of trade has to start with the company's pleaded case, which is in the core bundle at tab 11, page 115. So paragraph 26 is the pleading that there is a restraint, and it's clear from the main part of paragraph 26 that the only complaint is that clause 12 constitutes a restraint of trade. Now, some other clauses are mentioned at paragraph 26c, and it is said in the first line of C that there is a general imbalance of benefits and burdens. But those clauses that are mentioned, that are listed there, are not said to be in restraint of trade. They're not said to be unusual. They're not said to be exorbitant. They're not said, nor is any other like adjective used of the sort which my learned friend has used in his submissions in this court. Now, we addressed the case that's pleaded here, paragraph 26, in evidence. We brought evidence ourselves. We sought and obtained disclosure in the face of resistance to disclosure, I should add. I cross-examined the company's directors on the evidence and the allegation, and the judge rejected the case on the facts. If any of the claims that my learned friend has made in this court about those additional clauses have been pleaded, then there would have been evidence from us and disclosure from the other side going to those issues, cross-examination and submissions going to the pleading, whether they constituted a practical restraint, whether they were exorbitant or unusual, or whatever the allegation would have been. And just returning to the Chancellor's observation that he cannot simply decide whether clauses are unusual or exorbitant. If the case being advanced by my learned friend in this court had been pleaded, it would have been addressed in evidence and submissions, and the judge would have made findings which this court would then review in accordance with its practice. And in particular, we would have also had a proper discussion and decision on the meaning and effect of the clauses that we've just been discussing. The clause 5.1, because it's mentioned in the grounds of appeal as a separate ground of appeal, I'm going to make it the subject of specific submissions. The position is different in respect of the other points that my learned friend has raised. So, for example, the poison pill argument, which he referred to yesterday. On checking that, I find that was mentioned briefly in argument at trial. I mean, at trial, my learned friend did throw around clauses like confetti. But it was not developed the way it's developed now, and in particular, the poison pill argument doesn't find its way even into the grounds of appeal to this court. And so I'll be submitting that it's just simply quite wrong for your lordships to entertain the newly constructed case that my friend is advancing in this court when having met and decisively defeated on the evidence the case he did advance at trial, he's now seeking to create something different. My lords, the next thing I need to address is the structure of the judgment on restraint of trade, because it's very important that you understand how it works. And so we're in the core bundle at tab 7, page 93. And I divide it into 4 parts. So the first part is the heading, the legal principles, paragraphs 46 to 50. And here the judge considered the legal principles, and he concluded that he should proceed by reference to the 3 questions at paragraph 50. I've called these questions the quantum questions just because I need a name for them. So I'm going to, in this court, I'm going to call them the quantum questions, referring to these questions 1, 2, and 3. So the first quantum question is whether or not, in practical terms, the restraints in the contract amount to restraint of trade. The second quantum question is whether, even if it does amount to restraint, the covenant should be excluded from the application of the doctrine, because not every contract which is in restraint of trade is within the ambit of the doctrine. And this is the question that was the subject of the Supreme Court's case of Peninsula Securities, which I need to go to. And then the third quantum question is whether or not the covenant is justified because it's reasonable. So the second part of the judgment, actually before I move on, let me identify the grounds of appeal that relate to each part. So on this part, ground of appeal 4A contends that the judge was wrong to ask himself the first quantum question at all. So the second part of the judgment comprises the heading, is there a restraint in this case? Paragraphs 51 to 69. So here the judge addressed the first quantum question on the facts, i.e. whether the license agreement involved a restraint at all, and he concluded that it didn't. And grounds 4B and 5 challenged that evaluation. Then the third part of the judgment is paragraphs 70 to 80. And here the judge addressed the second and third quantum questions. So that's the question of public policy and reasonableness. And he concluded that the license agreement did not offend public policy and was reasonable. And grounds 4B and 5 also touch on this issue. And then I treat paragraphs 81 and 82 as the fourth part of the judgment, because here he's considering the high watermark of the company's submissions concerning clause 5.1 of the agreement. And he rejected that case too. And that's the subject of ground 6. So those are the 4 sections of the judgment. And I've identified the grounds of appeal relating to each one. And those are the 4 headings under which I'm proposing to address your lordships. So I'm turned to the first heading, which is the legal question raised by ground 4A. And this is on page 68 of our skeleton argument. Now, my lord put to my learned friend that the first critical question is whether or not there is a fetter, which is what I call the first quantum question. And while my learned friend didn't quibble at that stage, he then did develop ground 4A, so I do need to deal with it. That ground is that the judge was wrong to address the first quantum question as a standalone question. And it's implicit in that there is this concept that you can have a contract in restraint of trade that does not actually restrain either party's freedom to trade in a practical sense, and that's obviously wrong. as we know, the doctrine of restraint of trade is not a means by which companies can get out of contracts. We're grown to dislike. It's based on the public policy that parties should be free to trade. And we saw that in one or two of the authorities my learned friend took you to. We've given some authorities in our skeleton argument, paragraph 30, that I'm not proposing to go to because I don't think that's controversial. So it's not all contractual covenants which are prima facie invalid. It's not all commercial contracts which are subject to this public policy test and which require justification. It's only those which actually involve a restraint of trade. I mean, it would be a fundamental interference with freedom of contract and have huge ramifications for English contract law if a party that was dissatisfied with a bargain could invoke the doctrine and subject a contract to an examination of its reasonableness and public policy and justification and all of that without first having to demonstrate that it involved an actual practical restraint of trade. And the cases make it absolutely clear that that first question is a preliminary first question. So I need to make good that submission by showing you which the case is. So I can do this quite quickly because my learned friend took you to some of these. So the first case is Petrofina in the authorities bundle, tab 7. And my learned friend showed you paragraph 245D. And this is the basic formulation of the first quantum question, which has been approved by the House of Lords, the Privy Council, and by the Supreme Court. My Lord, that formulation was then approved and adopted.
That you say is the right question.
That's the right first question. Yes.
The right first question.
Yes, indeed. And that was approved and adopted by the House of Lords in Esso by, if not all of the judges, many of them. I've given you the references so in the skeleton, so let's not spend time showing you them. Yeah, so I've given you the references. It's approved by Esso. Then you have Stenhouse, which is tab 10, starting at page 348 of the bundle. And your lordships have seen the contract and the clause in question. And I'm on page 359 at F. Clause 5 is a stipulation of a different character. It's not on its face a restraint at all. Nevertheless, the board dealt with the clause at 359 going over to the top of 360. Their evaluation, and I stress evaluation, is that this clause operated at a practical level as a restraint of trade. And you see from the bottom of page 359 that they're adopting the approach in Esso, which in turn adopted the approach in Petrofina, the Petrofina formulation. You see that at H. So far, all of these cases have insisted on what I call the first quantum question as a standalone first question. The next case is the George Michael case at tab 13, page 393, Panayatu, in which Mr. Justice Jonathan Parker brought some useful clarity to the position. And as my learned friend correctly said, he conducted quite an extensive review of the authorities. I'm just going to go straight to his conclusions. So at page 485, at B1, the court's approach to the application of the doctrine of restraint of trade to a particular contract falls into two stages. The first stage is to determine whether the contract is one which attracts the doctrine of restraint of trade. But not every contract which is in restraint of trade, using that expression in a broad popular sense, to mean any contract which limits the free trade exercise of trade of business, per Lord Wilberforce, will attract the doctrine. If it is concluded the contract is one which attracts the doctrine, that is to say, if it is in restraint of trade, using that expression this time as a term of art covering those contracts which are to be regarded as offending a rule of public policy, the second stage is to determine whether it satisfies the Nordenfeld test. The Nordenfeld test is the test of reasonableness. And then that was based on Esso, which you see from the following pages, his analysis. And
So is Mr. Parker J's first test actually the second test?
yes, and that's clear. Yes, and that's clear from B2.6.
Is that where we're going?
So B2.6 on page 491. He splits out my first two questions in B2.6. That being so, it follows in my judgment that a right approach for the court, once it is satisfied that the contract before it is a contract which is in ordinary parlance in restraint of trade, is to consider whether in all the circumstances sufficient grounds exist for excluding that contract from the application of the doctrine. As Lord Wilberforce put it, to dispense the contract from the necessity of justification. If no sufficient grounds exist, the contract attracts the doctrine. By attracts the doctrine, he means therefore needs to go on to the Nordenfeld test justification. So Mr. Justice Jonathan Parker has identified three questions. The first is whether the contract is in ordinary parlance, or in a broad popular sense, in restraint of trade. The second is whether, if so, the doctrine of restraint of trade applies to it or is excluded. B2.6 makes clear that those first two questions are two different questions to be asked. And then the third question is the test of reasonableness, which he calls the Nordenfeld test. So those are the three quantum questions. And indeed, the wording of the second quantum question seems, to us at least, to be based on B2.6. You can see that B2.6 was influential on the formulation of the second question. So B1.1 refers to two stages, but those two stages only apply if you've decided that the contract is in restraint of trade in ordinary parlance, i.e. in the Petrofina sense, i.e. after you've asked the first quantum question. So, at the risk of repeating myself, but it's going to be important in a moment, what he calls the two stages are what will become the second and third quantum questions. That's followed through in proactive. So just to show you that proactive adopts the same taxonomy, that's in tab 16, page 621, it starts. So 57 to 59, the sidelined passage, you can see Lady Justice Ardern adopting Mr. Justice Jonathan Parker's approach. And again, when they're talking about the two stages, these are two stages that are applied once you've found that it is in fact a restraint of trade in the Petrofina sense, or the Esso sense, if you like, or the Stenhouse sense. And the judge certainly understood this passage in proactive in the way in which I've just explained it to you. That's paragraph 70 of his judgment. My Lord, the next case is Peninsula Securities. So that's begins at 849 of the bundle. So in this case, as the head note explains, the developer of a shopping centre in Northern Ireland leased part of it to the lessee, a well-known retailer, covenanting not to permit any major store to be built on the rest of the site in competition with the lessee. And the issue before the courts at that stage was whether that had to be justified at all So it was, the third quantum question wasn't an issue. The question was, do you get to the third quantum question? And that turned on what I call the second quantum question. And the debate and its resolution can be seen from the headnote. But essentially, what the Supreme Court said is that in order to decide whether the doctrine is engaged, they would apply the trading society test. So that was effectively their way of tackling the second quantum question. And you see the trading society test described in two places by Lord Wilson. The first is in paragraph 26 on page 872. If your lordships could just read 26. The key point is that this is a test which is applied to restrictive covenants, i.e. you don't get to this unless you've already found that there is a restriction. You see that just above C. Averting to restrictive covenants imposed on the sale of seats of land, he then defines the trading society test. And you see the same point in Lord Wilson's second definition of the trading society test at paragraph 46. Under the trading society test, a covenant which restrains the use of land does not engage the doctrine if. So you're assuming that the covenant already restrains, in this case, the use of land. So you've already answered the first quantum question, and then you apply the trading society test, even if it restrains the use of land, doesn't engage the doctrine if, and then it's defined. And just to make this absolutely clear, dispel all doubt about what I'm saying, if you go to paragraph 17, Lord Wilson records that at the hearing before us, no doubt fortified by early judicial encouragement, Mr. Michael Humphreys presented a preliminary argument, I underline preliminary. It was founded on the fact that Mr. Shortall was and is a property developer and that Peninsula was and is a property holding company, neither of them was a trader. How then ran the argument, could any restraint amount to a restraint of trade? In this case, it was a focus on the word trade, but clearly the preliminary argument was whether there's a restraint at all that needs to go on to the second question, the trading society question, and if necessary, the third question. And Lord Wilson says on this point that he agreed with Lord Carnworth at paragraph 64, and just now can't find, yes, there it is, sorry, it's between D and E. On analysis, the argument appears to be too narrow. In paragraph 64 below, Lord Carnworth argues persuasively the doctrine extends to restraints not only of trade but also more generally of business. And if we go to 64...
Fascinating end to the paragraph you've just been reading.
Sorry?
The fascinating end to the paragraph you've just been reading from. British Motor Trade Association in Grey. After the war, you couldn't sell a new car for 2 years. Not a restraint of trade. Nothing to do with this case at all.
Yes. Okay. Paragraph 64 has Lord Carnworth applying the Petrofina approach as the preliminary question, preliminary being the word used by Lord Wilson. So what the Supreme Court is doing there is saying, just as a preliminary question, we've got to check that this actually is a restraint of trade in the Petrofina sense. And then we'll go on to apply the second question to see whether it engages the doctrine. And the finding was that because of the nature of the covenant in question, it didn't engage the doctrine, i.e. the answer to the second quantum question was that, and therefore you didn't get to the question of justification. The contract was enforceable. So the contract was caught by the first question, but escaped by the second question.
So, Mr. Raven, just make sure I've not misunderstood this. So, what your submission is from these cases is that it comes down to one has to be very careful about the words restraint of trade, because, and this is really what Mr. Justice Parker is saying, because it is possible to find something which is, in ordinary parlance, perfectly accurately to be described as a restraint, and trade now means business, so anything businessy, and it's a restraint. So it is a restraint of trade in that sense. But nevertheless, it will, if the facts are appropriate, it will not engage the doctrine at all. It doesn't have to be found to be reasonable or anything. It will simply not engage the doctrine unless it passes the second, what you call the second quantum test. And whereas in a lot of older cases, the way it was written, and I think in Nordenfeld, essentially the way it was put is, well, if it's a restraint of trade, it has to be reasonable. And in fact, the modern law isn't as simple as that. The modern law is, if you're just using the language restraint of trade, some restraints of trade don't even have to worry about whether they're reasonable or not, because they fall outside the category of restraints of trade for which you have to worry.
Precisely, and Peninsula Stores was held to fall into that category. It didn't have to be justified. But in every case, to even get to justification, it has to be, well, to even get to the second question about whether it's engaged, it does have to be a restraint, and that's the very surprising argument that I have to make on ground 4A. It's just very helpful that Lady Justice Carr split out the three questions in that way, as your Lordship has just accurately described them. So she set those out on page 908 of the bundle. And I trust that it's okay, it's acceptable not to say, as she then was on every occasion. That summary on paragraph 68 on page 908, setting out the three questions, was based on a really substantial review of the authorities over the previous pages. And I just want to highlight a few points arising from that. The first is on page 905, Little Roman 5. The assessment of the application of the doctrine is to be carried out by reference to the position as the time the contract was made. How the contract turns out may be relevant, but only insofar as it furnishes evidence of the nature of the contract in question when made. And one of the authorities is Lady Justice Arden in Proactive, which she abbreviates to PSM. That's relevant to ground 4B. Then 60 sub Little Roman 6, the application depends less on legal niceties or theoretical probabilities than on the practical effect of the restraint in hampering the freedom to trade. And that refers to passages from SO and Stenhouse that I've referred to. And then paragraph 66, my learned friend relied on. There is a degree of overlap between the two stages. But as my Lord has just explained, one needs to be a bit careful about when talking about a restraint. And as I've demonstrated, the two stages here are the two stages to be applied to a covenant which is a restraint in the practical sense. And you
So just to put it in my own words, Mr. Raven, what you're saying there is that the overlap described there is between quantum questions 2 and 3, not quantum questions 1, 2 and 3.
Correct, and you can see that from the next passage over the page. I'm back on 908 now. So at 68, Lady Justice Carr sets out the question. At 69, she addresses the first question. It's common ground that the restraints in the covenants constitute a practical restraint of trade in a literal sense, so as to satisfy the first question.
The literal sense is an echo of in common parlance.
Exactly, and she's considered, I'm not sure.
Was that Mr. Justice?
You're right,
Parker's
Mr. Justice
expression?
Jonathan Parker, yes, which is then picked up in Proactive, which is heavily relied on by Lady Justice Carr. But yes, in a literal sense, I would suggest.
That's the Petrofina test.
In the Petrofina sense, I would have rather she said, respectfully. Then the second question, she addresses at paragraph 70 under ground 1. It's necessary first to consider the correct approach in law to be taken to the question of whether or not the threshold to engagement of the doctrine is crossed. So that's the second question. And then the third question she deals with at paragraph 95. The judge considered further question of reasonableness, that's the third question, in a separate section, but he expressly recognised, as reflected in the analysis above, such considerations can inform both stages of the exercise. So that's obviously talking about questions 2 and 3, because stage 1 of what I call question 1, that's just common ground. So the 2 stages of the exercise are quantum question 2 and quantum question 3. And again, I see no basis for interfering with his conclusion that in any event, and even if the doctrine were applicable, the covenants were reasonable. So that's the end of my learned friend's ground 4A. So I'm going to move on from the legal question, if your lordships are content, to the second heading of my submissions, which relates to the judge's answer to the first quantum question. So this heading is on page 70 of the Foundation Skeleton Argument, and this heading concerns paragraphs 51 to 69 of the judgment. Please can you have those paragraphs? They start on page 94 of the bundle. My lords, we've seen from the cases, Petrofina, Stenhouse, right up to Quantum Advisory, paragraph 60, sub little Roman 6, that the question whether a contract operates as a restraint of trade in a practical sense requires an evaluation. It's an evaluative determination, with all that that means in this court. The judge considered whether the pleaded allegation was a restraint in that sense, and made his evaluation, and we say that that conclusion was not only open to him, it was inevitable on the pleadings and the evidence, and it's certainly not anything with which this court can and should interfere. Now, if I may break down this section, paragraphs 51 to 69, the judge directed himself by reference to the correct principles at 52 and 53, and I've shown you those passages. Then from 54, the judge recounted the difficulties which the company had had in finding a restraint in the license agreement. He explained that the case advanced in the company's initial pleading was unsustainable as a matter of fact and had to be deleted. So he quotes at the end of 54 the original pleading and records at 55 that it had to be deleted because it just didn't work on the facts. That's 56. Then at 57, he turns to Mr. Block's submissions. He didn't confine himself strictly to the pleading, but did consider the points that Mr. Block had put to him. And as he discussed and explained, the bald allegation that clause 12 is an unreasonable restraint of trade was never a serious proposition. There was never any coherent explanation how clause 12 restricted the company's liberty to carry on trade in such a manner as it chooses, or hampers the company's freedom of trade, nor anything else in the license agreement. At paragraph 61, he refers to clause 5.1. Now, as the judge, as we'll be discussing, this was the high point of the company's case in submissions, clause 5.1. And it was a wholly new case, which I'm going to address separately. But the fact that clause 5.1 was my learned friend's focus in closing, well, reply submissions was a clear admission that the pleaded case, such as it was, could not sensibly be advanced. And I say the same about the yet further version of the case, or yet further case that my learned friend advances in this court. The fact that he's now relying on things like the poison, what he calls the poison pill and other things, underlines the failure of the pleaded case. Nevertheless, the judge was not strict about the pleading. He addressed the points put by the company in argument at 57 to 69. He gave them careful consideration, and at the end he concluded that the company is not subject to restraint in any meaningful sense. My learned friend drew attention to the last sentence of paragraph 69. All the company says it is prevented from doing is managing its very successful business in a different way, but to my mind that's not enough. Now, managing its very successful business in a different way, that's a clear reference to 5.1. So he's effectively saying, apart from all they're saying is 5.1 has its effect, but that's not enough. And as I say, I'm going to deal with 5.1 head on, but separately. The judge was right to observe at 68 to 69 that all the company could establish was that it had come to think that although it still wishes to trade under the name Zaha Hadid, it would be better off with a different set of terms. Now, that, as I say, that's an evaluation, an evaluative decision for the first instance judge to make. Furthermore, it was based on an assessment of the evidence, and that included a lot of material. There were disclosure bundles at trial running to over 2,000 pages of material. Now, you don't have that material, but you can get a flavour of it from just by glancing at my skeleton argument below. So if your lordships go to the supplemental bundle, tab 12, page 143, This is an annex to my skeleton argument at trial, and it identified documents supporting the point that the company had flourished since the license agreement was signed. And we've seen the authorities how the practical operation of the contract can be relevant to whether it operates as a restraint of trade in a practical sense, and I'll be addressing that in more detail in a moment. This was also particularly relevant to a point that was developed, that was pressed heavily at first instance, but not in this case, not in this court, that the amount of the license fee rendered the company unviable. But as you see, there were lots of documents which we quoted extensively and relied on. And the second annex, at page 156, dealt with the value of the name Zaha Hadid to the company, which was relevant to all the quantum questions. That was the first annex. In addition to this material, which is you get a flavour of, the judge also had witness statements from two directors of the company on this question. Mr. Walker was the primary witness on this. He addressed in detail the practical effects of the license agreement on the company's business, and the judge heard detailed cross-examination on that evidence, which involved exploring many of the disclosure documents and the operation of the license in practice and just how it worked. And the judge noted at paragraph 59, in particular, the value of the cross-examination of Mr. Walker on this topic. That's paragraph 59 of his judgment on page 95 of the core bundle. The second sentence. So we say that this is a classic Fage and Shabani case. It's worse than island hopping because my learned friend has not even taken you to any of the islands. You've gone to a completely different resort. I said that there was a lot of material before the judge that this court does not have. One of the few relevant documents in the appeal bundles is the company's letter to the foundation in June 2023, which kicked off this dispute, and it is relevant to a number of the submissions that my learned friend has made in this appeal. So please could you go to tab 2 of the supplemental bundle, page 5. this letter was more than 9 years after the licence agreement was signed and more than 7 years after Dame Zaha's death. So the licence agreement was firmly part of the world when it was written, and it's the letter which really kicked off the dispute, which has now found its way to this court. You can see from the paragraph in the middle that the complaint was that the licence agreement was no longer fit for purpose. That's almost right in the middle of the page. The words no longer fit for purpose implies that it was fit for purpose when it was made, which is the relevant date for assessment. And I would also say that the phrase fit for purpose is a carefully chosen word, but is not sufficient, remotely sufficient for the purposes of any of the submissions that my learned friend makes. The letter implies that it's no longer, the letter states that it's no longer fit for purpose in 3 respects in the bullet points. The trademark agreement is not an exclusive license, not something which is part of my learned friend's case now. The indemnities granted by Zaha ZHL, that's the company, are highly onerous. Well, I don't think my learned friend has drawn your attention to any indemnities. And the trademark agreement contains an entitlement for the licensor, you, to terminate at will for no reason. That was something raised at trial, doesn't seem to be an issue in this court. But no complaint you see that the licensee doesn't have the right to terminate. That's just not seen as a problem. And then finally, fourthly, in the paragraph that doesn't have a bullet, we're also concerned about long-term affordability. That was something which was pressed heavily below. I dealt with it head on below. I defeated it on the evidence, and it melted away. It didn't really, by the time of closing submissions, that point was gone, and it's not been resurrected. That's a good example of the fact that if they give us proper notice and pleading of a point of a complaint about this license agreement, we will deal with it on the evidence and in submissions.
I thought you'd just taken us to paragraph 59, where the point was very much part of the judge's thinking.
The long-term affordability.
Yes, it's the stones in your pocket.
Yes, yes. By closing, but the judge definitely dealt with it. By closing, it sort of, my recollection was that it featured less heavily in closing after I'd cross-examined on the proposition. The judge dealt with it, he evaluated it, he considered the evidence, and
yes, I'm not taking issue with that point, but I'm just surprised to hear you say that it had gone by the time by the end of the case, because it seems to be what the judge considered to be the main argument that is being advanced.
I'm sorry if my form of expression was inaccurate. The point I was trying to make was that it was definitely relied on less heavily at the end by my learned friend at the end of trial than at the beginning of the trial, and that I took to be the result of the fact that we'd had evidence and cross-examination on the point, and I just raised that to underline my submission, which I've made too many times already, that these are matters which require evidential analysis and evaluation. Obviously, the point I make about this letter is that none of the complaints that my learned friend has put at the forefront of his submission in this court were raised in this letter, and that's not just a pleading point, it's also powerful evidence that they are manufactured by the litigation team and not real impacts on the business. And that's then re-emphasised by, for example, the fact that the poison pill allegation was not even raised in the grounds of appeal to this court.
Can I raise you something that's slightly troubling me on this aspect? You summarised what the judge decided on this question. I don't think unfairly, it's 68 to 69, that all the company could establish was that it had come to think that although it still wishes to trade under the name Zaha Hadid, it would be better off with a different set of terms. And you say that's an evaluative assessment. And I can understand that that was the question that the judge was addressing at stage 1 in the light of the submissions that were made to him. But is it the right question? It seems to me that since we're dealing with whether there's a restraint of trade on the assumption that this agreement cannot be put to an end by the licensee on notice and therefore operates in perpetuity, isn't the question whether it satisfies the Petrofina test in foreseeable circumstances in which it no longer wished to use the license, and indeed in which use of the license might be positively detrimental to its business?
There are a number of answers to that. The first is that the judge could only deal with the case that was advanced to him.
If I understand.
And
On the other hand, we have to decide what the true position is.
Indeed. And whereas when it comes to construction of contracts, this court takes its own view, and I don't believe I've made any complaints about my learned friend running arguments on construction that he didn't run below. On a matter like this, this court only has to review the judge's decision, and one of the many reasons for that, given in the authorities, is that if the case had been put the way your lordship has put it to me, I would have dealt with it on that basis, and I certainly would have cross-examined Mr. Walker, principally Mr. Walker, on the question that, as your lordship has just formulated it, if that had been the question that had been formulated in the pleading.
Would it have been a matter for evidence? I mean, would it not be self-evident that there might arise circumstances in which it was no longer in the company's interest to use the marks, and in which it would be detrimental to their business to do so? That's a series of hypotheticals, not really what the witnesses would have thought about it.
Well, we did come quite close to that, in that the point was put somewhat beyond the pleading, but the point was put that what was being paid was too much for the company's name in the circumstance. I know that's not the same question, because you're talking about hypothetical future, whereas that was referring to the position as it currently obtained. But I did cross-examine extensively on that question, the value of the name to the company, what it meant, and its value, particularly because they were saying that they were paying too much for it.
That's as of now, is it?
No, indeed. My point is the less ambitious one, which is, I'm not saying I answered that case. What I make that point to show you that I dealt with that allegation on the evidence, and I could have addressed evidence and cross-examination to that question if it was a relevant question.
Well, it's the second half of that I'm just questioning, because it's a hypothetical question. It's not what the directors think in the current circumstances.
Indeed.
It is what would the position be if one of the buildings had collapsed, or the various hypotheticals we've been talking about. And that's,
Indeed.
in a sense, it's not for the witnesses to say, if one composites circumstances in which it is obvious that it would not be in the company's interest to continue to promote the marks, then doesn't the threshold question one, as to whether, in a literal sense, the perpetual nature of the agreement would interfere with the freedom to trade as they wished, isn't that a question that just has to be asked on that assumed basis?
So I can think immediately of areas where evidence would be relevant to that question. The most obvious is that the Petrofina test, as we're calling it, relates to a practical issue. And there obviously, I understand the point you're talking about, one can foresee circumstances, but there's a question about whether circumstances are foreseeable, what is purely theoretical and manufactured by a litigation team, and what is a realistic possibility, and we're only concerned with the latter. And those are questions which are properly matters to be explored in evidence. You see from the judgment that certain future matters, not these sort of matters, but certain future possibilities were canvassed in the evidence and explored in in the evidence. So that's one area where that would be a that evidence would be relevant. It's also a fair point to make that would be that's not an appellate function what your lordship is describing. Your lordship is describing making it about the first time out evaluation, which was a matter for the first instance judge, and it is wrong in principle that these issues can be taken and raised for the first time in this court when that is the proper function. It shouldn't be for me on my feet to respond to the questions of that sort. That question should have been put to me by my instructing solicitors in early 2024 for us to consider what are we going to say about that. We had evidence. We had evidence from Sir Brian Clark, who was a major figure in architecture, who could. I would have asked him that question for a start, and no doubt would have discussed these matters with my clients and with those in the industry, so that we could address those points. I totally understand why your lordship is putting them to me now, but the reason for pleading is so that counsel is not asked those questions on his feet in the Court of Appeal, but at the outset of the case when the disclosure is being considered. As I said, we had a dispute over whether there should be disclosure at all. I understand that once it had been decided there should be disclosure, it wasn't difficult. It was possible to agree the scope of disclosure. We didn't have any further disputes about disclosure, but the scope of disclosure definitely would have been different if different arguments had been made. And again, that's something that I would have discussed with my instructing solicitors in 2024, and not having to think of an answer to your lordship in the Court of Appeal.
Thank you.
Mr. Abrams, I'm going over the same ground. I apologise, but the bit that I'm struggling with at the moment is that what I'm going to call normal trademark licence would have clauses very like many of the clauses in this trademark licence, including a clause which says you've got to use the mark to some degree for the reasons you've articulated. And at least on one view, this trademark licence has a clause in it exactly like that for the same reasons. That is a fetter on trade, because it restricts the ability of a trader, the licensee, as to what brands to use on their goods or services. It just is. It doesn't need evidence. Now, the bit that makes it arguably a restraint of trade of any interest, which is what this case is about, is the point that's put against you, that's pleaded, that it's Clause 12's lack of ability to get out of it that makes it a restraint of trade which is worthy of consideration. But the restraint, the basic, very simple fetter on the freedom of any businessman or trader or whatever to sell their goods or services in any way they see fit, is that this contract says you've got to use this mark. And I'm struggling to see why that isn't, in a petrophile sense, a straightforward, literal restraint on trade. And then the question is, when you add it to the clause 12, where do you go? Now, I do sympathise, Mr. Abrams. You can fairly say, as you just have, that your opponents didn't say that, and they produced lots of, and I'm now paraphrasing your argument, they produced lots of duff arguments on the facts, which you defeated on the facts. Well, maybe they did, and maybe you did, but in the end, the case is that it's the lack of the termination which is the root of the restraint of trade, and it's the licence itself which effectively amounts to a restraint of trade because it can't be terminated. That's as I try to fairly paraphrase Mr. Clark's case.
So I think there are two main answers to that, what you've just put to me. The first is that I wouldn't accept, I'm not sure this is a complete answer, that your lordship may say this is a complete answer, that 5.1 doesn't prohibit the use of other brands as well, because licensed services is defined as including but not limited to other brands.
Right.
So it's not a fetter in that sense. The second point is that even were that so, you then got to consider the second and third questions, and I'll be addressing those in due course, in particular in relation to 5.1. I keep promising that I've got a whole separate section on 5.1, and that will include the second and third
Well,
questions.
I quite see that you say that you win on reasonableness and all that in the end. I get that, but the question is whether you even get there. That's the
Yes. No. Well, that's and so on that narrow point, I would say that 5.1 is not a relevant fetter in that sense because it doesn't prevent them using other brands, and I do take the point that this could have been done, and this question could have been explored in more detail if it had been raised properly and not raised in reply. Again, whether it's a fetter in a practical sense, while I accept you've got to look at foreseeable circumstances, is nevertheless something that can be discussed with a witness as to whether this is realistic and whether it's actually going to make any difference at all. And the same goes for the second and third questions.
Okay.
But that's my answer. My Lord, before I go to the second and third quantum questions, I was going to quickly run through the individual grounds under 4B and 5, which we have done in our skeleton argument. So I'm at page 72 of our skeleton argument. Some of these, my learned friend definitely did press in argument. Others, I'm not sure about. I'll do them all as quickly as I can. So, ground 4B is that in determining whether there was a restraint, the judge wrongly took account of the company's profitability, contrary to proactive, and that's a bad point as a matter of fact and law. First of all, the statements in proactive don't bear the weight put on them by the company. All that the judges in that case said was, well, the fact that the contract has turned out to be profitable is not an answer to the case which has been advanced by Mr. Rooney and established on the evidence. It's notable that the statements about profitability made by Lady Justice Arden and Lord Justice Gross in proactive appear at the end of the judgments, end of their respective judgments, i.e. having found that there is a restraint and considering the second and third stages, the profitability, or considering particularly the third stage, having found a restraint, the fact that it's profitable doesn't excuse it. Those judgments don't touch on the question of what facts can be looked at as part of the evaluation whether there is a practical restraint. Second, it's well established that how the contract turns out may be relevant insofar as it furnishes evidence of the nature of the contract in question when made. That was a point made by Lord Justice Gross in proactive, and I showed you Lady Justice Carr in quantum advisory endorsing that. That's paragraph 60, little Roman 5 of quantum advisory. Thirdly, and perhaps this should be my first point, the judge didn't do what he's accused of under paragraph 4B. So if we go to the core bundle, page 94, the judge referred to the company's turnover and profit at paragraph 55 to 56 when he was recounting the history of the pleadings, and specifically he's explaining here why the company's original pleading had to be deleted. So that's 55 and 56. When the judge evaluated the license agreement, he did that at 63 to 69 in accordance with the approach mandated in Petrofina, Stenhouse, Quantum Advisory, etc., focusing on the practical effect of the contract. The judge did not rely on the profitability of the company as a reason for saying the license agreement imposed no practical restraint. To the extent that he averted to the company's success in any parts of the judgment, he came nowhere near committing the alleged error of treating the company's profitability as an answer to the case on restraint of trade. His point was simply that the license agreement does not on its face appear to contain any restraint, nor can one see one operating in practice. There's no error there. Ground 5A is that, as a matter of fact, the judge erred in finding that the licence agreement was the result of a bargain struck between the parties. This, I think, must be relevant to the second and third quantum questions rather than the first, but I'll deal with it now nevertheless. So this was a factual issue which was explored at trial, where the parties' respective positions were in fact quite different to what they are now. The company's position was set out in its reply at paragraph 11 and elaborated in its trial skeleton argument. So I'll just show you the trial skeleton argument. That's in the supplemental bundle at page 95. So paragraph 85 is my learned friend making a submission entirely in accordance with his pleadings. And he makes the point that the agreement itself purports to be an arm's length agreement. And that's demonstrated by its provisions itself. I said I wouldn't show you I wasn't going to go to the pleading, but I just realised the pleading does contain something in an additional point. It specifically pleads that it's in page 66 of the same bundle. Paragraph 11. The second sentence at the top of page 67 specifically pleads that it was one that was entered into in the interests of both parties. The judge's conclusion on this is at paragraph 77 of the judgment. That's page 99 of the bundle. The point he's making here is that the license agreement was signed by Mr. Schumacher in his capacity as a director of the company. It's his choice to sign it and his choice as to what steps to take before doing so, for example, seeking legal advice. Now, this doesn't form any part of the decision on the first quantum question. This is in the section of the judgment on the second quantum question, and this was a perfectly proper matter for the judge to take into account on the second and third quantum questions. So there's no possibility of an error here. I can finish ground 5 before the short adjournment. Ground 5B, you've still got the judgment open. Ground 5B is that the judge wrongly assessed each of the clauses of the license agreement in isolation, just simply not correct. The judge recorded the company's submission at 58 and gave it careful consideration in the following paragraphs. 66 to 67 particularly refer to the clauses taken in combination. Obviously he's addressing the case put to him. And ground 5C is that the judge adopted too narrow an approach to the manner in which the clauses of the license agreement can, in terms of their practical effect, operate as a restraint of trade. Too narrow an approach I take to be a complaint about misdirection in law. Again, it's simply wrong. Your Lordships can see from paragraphs 52 and 53 that the judge directed himself correctly that he should be focusing on the practical effect of the alleged restraint, and you can see him doing that in the following paragraphs. My learned friend's complaint under this heading seems to be that the judge didn't consider points which were not pleaded and pursued in evidence. That seems to be the complaint there. Well, that was a quick run through those grounds. I was going to move on to the second and third quantum questions.
through as we, unless you're very worried, you and Mr. Block, about time, I propose that we rise now, but we will start again at 2, not at 1:45. So we are shaving 15 minutes off you, but I think from where your arguments have gone, I don't think that's going to put either of you in any difficulty.
On the assumption that a learned friend sits down when I anticipate he will sit down, it shouldn't cause me a problem.
Thank you, Mr. Block. Very good, 2 o'clock.
Court rise, Babel.